My name is Orin Kerr. I'm a law professor at George Washington University here in Washington, D.C. I think it's hard to generalize how the process from input to output works at the Supreme Court because you've got 9 different justices, and they're all individuals with their own approaches to cases, different ways of thinking about the law, different backgrounds, and so I don't think there's really one answer that explains kind of how the hierarchy of legal sources translates into a decision. I think in general, though, the justices are quite self-aware of who they are, what the influences are, the roles of the different parts of the process. All of them are very smart, and in a way that's different from perhaps justice in the past. These justices are almost all former Court of Appeals judges. I think it's a quite significant difference. The fact that today, I guess 8 of the 9 justices are former Court of Appeals judges. They've all been professionalized into the modes of judging, the process of reading the briefs, of oral argument, of working with law clerks, of working with each other. They've all done this and done this very well for years before they're on the Supreme Court. And so I think the processes are really internalized, but exactly how it works justice to justice just depends on that particular justice. I think on balance it's a good thing that most of the justices are former Court of Appeals judges because, and this no doubt reflects my own values and sense of the role of the Supreme Court. I tend to be more in the kind of judicial restraint side of legal debates. I think, for the Supreme Court to step in and say a practice is unconstitutional is a powerful and awesome thing to do, which should only be done in when justified and appropriate, and it's a pretty significant step. And as a result, I tend to like the idea of justices that were professionalized in legal norms and are following precedents or are sort of legal technicians themselves. My sense is that those who think it'd be better to have a politician on the court, or better to have someone who's coming from business, or even in some cases a non-lawyer, they tend to be those that would like the Supreme Court to decide cases in a more political way, or don't care that much about whether all the precedents line up, or maybe are less focused on the predictability of the law. Sort of coming from, I guess, what you could characterize as more of a Burkean conservative sort of view, I think, stability is not a bad thing. And I've sometimes thought, it wouldn't be the end of the world if the Supreme Court in a particular term granted no cases. So, it'd be boring for Supreme Court commentators, but the justices would not have the opportunity to mess up the law for a year. So, and it's just whenever the Supreme Court takes a case, maybe they'll improve the law, maybe they'll rationalize it, maybe they'll make it worse, maybe they'll create more questions than they answered. You never know if Supreme Court intervention is going to be a good thing or a bad thing. But having a court with legal technicians, with those that are kind of lawyers that take legal sources really seriously, I think leads to a more predictable set of opinions, that leads to a higher quality set of opinions. And here I think it's important to recognize the distinction between the high-profile cases, the big constitutional cases, gay marriage, affirmative action. Those are the cases that everybody focuses on, that get all the press attention. That's a very small part of the Supreme Court's docket. The run of the Supreme Court's docket is, a bankruptcy case, a tax case, a statutory interpretation case involving some arcane statute that nobody has heard about. That's most of what the Supreme Court does. And when you have legal technicians, those that are sort of lawyers, former Court of Appeals judges types, they care about those cases. And I was very impressed when I was a law clerk that the justices cared just as much about the minor cases that no one cared about as they did the major cases that were in the news. And the quality of those cases that that aren't making the news can vary dramatically depending on the interests and skills of that justice. So I think the level of Supreme Court opinions outside of the high-profile cases has gone way up over the last 50 years as you've had more and more professional justices. Um, in my experience, everyone wants justices that are wise Platonic guardians when they don't like the state of the law and think that that would mean that their sort of preferred version of the law would be enacted, and yet they want sort of technical legal types and those following precedent in areas where they like the body of law. So of course the difficulty is you can't come up with different justices for, depending on whether you like the current state of the law in one area or not, you kind of have to accept one answer across the board. My own preference is towards the Supreme Court playing a narrower role in American society. I think this is, from my perspective, reflecting basically a populist approach where I think, you know, we live in a democracy, a constitutional democracy, but nonetheless a democracy in which it should be up to the people to set the rules that they live under, and the Supreme Court should only step in when the Constitution, fairly construed, really says you can't do that. And in construing the Constitution, I think there should be a thumb on the scale against invading the area of democratic decision-making. And again, sort of reflecting my, you know, populist democratic ideals. First, I would question what it means for a branch of government to be dysfunctional. I think it's easy for someone to say a branch of government is dysfunctional when it's not functioning the way they would like it to. But you know, what is the standard for dysfunctional? I think in a democracy, the standard for dysfunctional, I guess, would reflect, you know, does it reflect public opinion? And looking at the current Congress is not enacting a lot in the way of legislation because the public is genuinely divided about what kinds of legislation should be enacted. So I don't think the current Congress is dysfunctional in that sense. And also, once you say a branch of government is dysfunctional, you know, if the Supreme Court steps in at that moment, it's going to step in at a time when it is making a judgment about the current Congress that will be long forgotten once that precedent is on the books. So looking back through history, we don't know if the Congress of 1932 or the Congress of 1917 or 1925 was dysfunctional. We remember the Supreme Court cases that were decided, and those cases go into the books and then become part of the precedents that later courts rely on to either expand or tailor those prior precedents. So I think it's wrong to look just at the current day and say, I make a judgment about the current system when trying to figure out where the Supreme Court should go. I think it's fair to view the court through a political lens. It doesn't tell you everything you need to know about the Supreme Court, but it unfortunately tells you a lot. And I mean unfortunately in the sense that it would be much better if a political lens were completely useless in analyzing the Supreme Court's work. But just from an outsider perspective, you know, if you look at the vote breakdown in a particular case, it often does match a fairly predictable framework. And part of that, I think, is just reflecting the reality that Supreme Court justices are nominated by politicians and confirmed by politicians. It's the two branches of government that have their say at the outset are political branches. So it shouldn't be shocking that the individuals that are on the court, to some extent, are going to reflect the environment in which they were nominated and confirmed. But I think it's unfortunate that that lens does shed light, but it's a reality. Sometimes you'll see a Supreme Court decision that has an unpredictable lineup, and everybody knows what the unpredictable lineup, what that means. No one says, well, unpredictable how? And everyone understands, okay, well, you've got your left of center justices and your right of center justices, and today Justice Kennedy is the swing justice. We understand that framework because it happens enough that it becomes a useful heuristic when talking about the Supreme Court. And unfortunately, that does map along directly political lines. Yeah, I think the political lens is a tool, but can't be the only tool. So it explains certain vote breakdowns. It's a way of thinking about how the court works, but there's so much more that goes into the justices' decisions. And one way of thinking about this, there's some very interesting political science research on how people view the work, any political decision. There was a study done in which a particular policy change was suggested to individuals, and then they were told either that this was a Republican proposal or a Democratic proposal. And people that considered themselves Republicans supported the proposal if Republicans purported to endorse it, and opposed it if Democrats purported to endorse it. And the idea is one that I think is pretty intuitive, which is that we make judgments about what is happening based on whether the people we associate with politically are in favor of it or against it, rather than conducting kind of a first principles analysis of what is consistent with our values. So if you see a Supreme Court case and it divides 5-4 along these sort of traditional political lines, and you consider yourself on one side, you're likely to see the case as a political case, as a close case, as one that involved ideology. If it's a unanimous case, you're likely to think, well, that was an easy case. That was one that maybe didn't raise any real political issues or was just sort of obvious on the law. Oftentimes, though, the Supreme Court will hand down a 9-0 decision in an area that actually does have some pretty significant political valence or is quite difficult on the law. And then similarly, you'll get a 5-4 case that divides on political lines on a case that actually did not raise any particular political implications or was actually pretty simple based on prior law. But from a public standpoint, we read the court's cases and we get signals about what is political or not political based on what we see as the vote breakdown, which is often quite different from how a case will look from inside the court. I think the fact that Supreme Court justices are nominated by politicians and confirmed by politicians, that the process by which they get to the court is a deeply political one, is going to mean that the justices themselves are going to some extent reflect if not the politics of an era, some sort of ideological reflection of the era in which they were nominated. And once you get 9 justices appointed to the court over time, there are going to naturally be individuals that share some of those views that they've held. So there will always be some aspect of the Supreme Court which reflects ideologies of individuals, usually ideologies of presidents of 20 years ago or 30 years ago or 10 years ago, not necessarily the kind of politics of the day. So the Supreme Court is not generally going to be, it's not going to be partisan in the sense of like, here are the Republicans, here are the Democrats, but you're going to have individuals who have ideological views reflecting the moment in which they were nominated and which they were confirmed, and that's in part by design. I mean, if you look at this tends to, I think, be an issue with more valence on the Republican side. You look at Republican presidential debates when they discuss the role of the Supreme Court. And individuals are asked, what kind of justice would you nominate? And they name, I would nominate like another Justice Scalia, or I would nominate another Justice Alito. They're sort of picking individuals who they see as reflecting a set of concerns and an approach and a view of the law that has favor in one party and not in another. The individuals themselves are not acting politically. They're just doing what they think is correct. But it will have the effect over time because of the process by which they got to the Supreme Court of reflecting ideologies which I think are fairly described as having some political valence. I think it's true that the court generally does not stray too far outside of the bounds of what is sort of generally accepted. There's been a big debate, I think really one raised by the Affordable Care Act case, of sort of to what extent does the Supreme Court adopt views that are kind of on the wall or off the wall? Does an idea need to be mainstream before it's accepted by 5 justices? And I think just as a descriptive matter, there's a lot to that view. The justices themselves are reflecting, the world in which they see themselves, their community, the legal community, even more specifically, the elite legal community, the Supreme Court bar, and they're in a world of commentary and opinion, and it tends to be the case that those who make it to the Supreme Court are mainstream in the sense that they're mainstream enough to be nominated and mainstream enough to be confirmed. So the individuals that make it to the Supreme Court usually are somewhere within, the 20-yard line to the 20-yard line at the time on which they're put on the Supreme Court. Add that up, and the Supreme Court requires 5 justices. They're not going to go in a place that's kind of radically out of step with public opinion, at least of the opinion of those who nominated them and confirmed them. I think it's hard to change that dynamic. It's just inherent in having a politician nominate a justice and having politicians confirm them that you'll have that. And to some extent, it acts on a check on the power of the court to strike down legislation. That it's. And I'm not saying this is the ideal system I would design, but in a weird way, it sort of works. That the justices should stay within the lines and should not be aggressive in enforcing their policy views and reading their own views into the Constitution. And at the same time, as a practical matter, they're likely to reflect some sort of a democratic norm in the collective because they are ultimately reflecting views of politicians who were popularly elected. So the sausage making may not be very appealing, but the system as a whole more or less works. With that said, I think there are there are a lot of debates as to the proper role of the Supreme Court, and they are absolutely live and valid and important debates. The system works kind of over time, but not in a very pretty way. I actually think the nomination and confirmation process works pretty well. Some expect the process to be this glorious academic enterprise in which we look deeply into the soul of the nominee, and the nominee shares their innermost thoughts. And we've never had that, with one exception, the nomination of Robert Bork. That's not the historical norm. The historical norm is not even to have hearings, live hearings. So the process today, though, I think works quite well. I mean, again, it depends on your standards, but I think in general have seen pretty high quality nominees representing the views of the president who is nominating them. I think today's justices are, on the whole, the smartest set of 9 justices we've seen, or at least way up there relative to the historical norm. The confirmation process is an opportunity for the public to get exposed to what the Supreme Court does. And it's also an opportunity for the two parties to kind of define the role of the Supreme Court, what they think is important. And an interesting example of this, I think, is the 2 most recent Supreme Court confirmations, those of Justice Kagan and Justice Sotomayor, both featured extensive discussion of the Second Amendment. That may seem sort of surprising in some sense, because there have not been, it's not historically been an issue that nominees were asked about, and it's reflecting recent case law developments, the Heller case and the McDonald versus City of Chicago case. But it's also a way in which one party, in this case the Republican Party, can show that it considers the Second Amendment to be a really important constitutional right. And in effect, it is a way in which the public is having the opportunity to influence views of constitutional law by putting forward a vision of how the Constitution works for, the senators are putting this forward for the public, and the justices, the nominees, are being told, this is very important to our side, effectively, or to our constituents. And it's a way in which the public, I think, has an impact on constitutional meeting, which strikes me in a system where, again, a politician nominates and politicians confirm as actually a way in which the system works. So it's not highbrow theory, and it's not Oprah Winfrey sort of let me tell you my innermost secrets, but it's a way in which the public impacts how the Supreme Court looks at its job and influences, I think, ultimately how the Constitution is construed.